Well, hello and welcome to everybody. Thank you so much for joining us here today. My name is Andrew Davis. I'm the Director of Research at the Decent Criminal Justice Reform Center down here at SMU Dedman School of Law in Dallas, Texas. I am really grateful to be joined today by Dr. David Abrams and Dr. Priyanka Goonetilleke, who are here to present their new work on the transition to vertical representation for some cases that occurred in Philadelphia back in about 2015 and 2016. Vertical representation is, of course, a salient issue in indigent and public defense policy debates. It's a principle that's mentioned by the ABA in one of the 10 principles that they say should underlie the provision of high quality indigent defense services. And yet, as far as I know, this is the first, or certainly the most robust and sophisticated attempt to address what difference vertical representation might make to clients. Particularly in light of the fact that at the same time in indigent defense and public defense policy, I think we're also facing policy pressure to consider things like more and more counsel at first appearance, for example, which offers a kind of a countervailing policy pressure in the sense that most attempts to implement counsel at first appearance actually result in more horizontal than vertical representation, at least in my experience. Anyway, David and Priyanka have some important new work to share with us on the impact of that policy as it was implemented in Philly. A little bit about the Decent Center. We are a research and reform center, as I said, based down here in Dallas. We do a lot of work around indigent defense, also in prosecutorial charging discretion, and also with a focus in rural areas. And this is our CJR workshop series, which is to say, this is our series of presentations by scholars, often junior scholars, who are presenting what might be early drafts of their most kind of cutting edge and newest work on the criminal justice reform themes that we care about most at the center. Dr. Goonetilleke is in fact himself on the job market right now. He is available for hire shortly, as I understand, and so please do bear that in mind as you are thinking about his very high quality work that he's about to show to you. I know that Dr. Abrams may still be trying to reach his office. He is dealing with a snowstorm, but Dr. Goonetilleke will certainly lead the presentation until Dr. Abrams is able to join us. I know that both of them are interested in speaking to this group because, of course, they're very interested in getting the response of people in the field of public defense to the implications of their findings. But they are also separately interested, or in addition interested, to hear from the researchers on the call about what we think of their empirical strategy. They're obviously working with real world data here. And so the question of how to identify successfully the exact increment of the changes that they can see and connect those back to the vertical representation transition is also something that I know that they're very open to feedback and criticism on, and eager to hear from everybody. So we do have a mixed group here today, and I'm going to now hand it over to Priyanka. He will speak for several minutes. At the end of that, I will come back on to moderate a Q&A session. Please, at that time, use the hand raising feature of Zoom to indicate that you would like to ask a question. And I will, unless it becomes too chaotic, which I don't expect, I will invite you to speak in the order that you stick your hand up. But for now, I will hand over to Dr. Goonetilleke. Thank you so much.
Thanks. Let me just share my slides. So thank you for the introduction, Andy, and thanks everyone for coming to the workshop. So as Andy mentioned, my name is Priyanka Goonetilleke, and I'm a visiting assistant professor at Northwestern Law. And today I want to present the paper that I've been working on with David Abrams, who's at Penn Law. So the goal of this project is to increase our understanding of how best to structure indigent defense. So as I'm sure you're all aware, there's a chronic issue of underfunding in public defense in the US. And as a result of that, we think it's very important that more empirical research is done to help us understand how to optimize the use of those resources. So in this project, We're looking at one specific aspect of this by trying to quantify the impact of continuity in representation in indigent defense. So, as many of you are no doubt aware, the ABA lists vertical representation as one of its 10 principles for an effective public defense system. And this is a model whereby a single attorney is assigned to handle the defendant's entire case. So from the initial appearance until the case is eventually disposed of. However, despite this recommendation by the ABA, many public defender offices throughout the US continue to use forms of horizontal representation. So in this model, you'll often have defense attorneys assigned either to specific stages of a case or to individual courtrooms. As a result of this, as the defendant's case progresses through the system, they'll be represented by by multiple attorneys. So often each stage will have a different attorney. The primary justification for the use of horizontal representation is efficiency. So by assigning an attorney to represent all of the cases in a given courtroom on a given day, the amount of time spent waiting in court or traveling between different courtrooms is reduced. And this might sound like quite a trivial thing, but one observational study found that almost 50% of an attorney's time in court was actually just spent waiting. This was an old study, so at a time when the courts were even less efficient than they are now, but it's still a substantial burden. Another potential benefit that's being suggested of horizontal representation is the idea that it provides a possibility of specialization. So this can either be in the stage of the criminal process or in terms of the relationship with the judge and prosecutor, and that as a result of this, it will improve the defense attorney's performance. And a final potential advantage that I'd like to suggest is that as a case moves between attorneys, there's the opportunity for mistakes to be caught. So attorneys are in effect able to check each other's work, and this might be particularly important for kind of more junior attorneys. However, against these advantages, many disadvantages of horizontal representation have been suggested. So first, given no single attorney owns the case, each may feel that they're not really responsible for the final outcome. And this can reduce incentives for case preparation. For example, attorneys assigned to the initial stages may leave the investigation and interviewing of witnesses to trial attorneys. But in addition, information might be lost as the case passes between different attorneys. So high caseloads might lead to insufficient communication between the different attorneys handling a case. And as a result, details that aren't officially recorded, such as observations about witnesses or off-the-record conversations with prosecutors, may be lost. The fact that attorneys tend to be with the same prosecutor and judge every day may also create conflicts where they have to consider the impacts of their actions in the current case on future clients. Such a conflict may be inevitable regardless of the representation model. However, intuitively, we would expect that the risk is heightened in a setting where the attorney is in front of the same judge each day. The efficiency gains that I suggested previously in terms of advantages may even be somewhat reduced due to the duplication of work. So, for example, each attorney assigned to the case will need to re-interview the defendant. On top of this, attorneys need to review the case notes from the previous attorney and also then write up detailed notes for the next. However, the primary disadvantage appears to be the impact on the attorney-client relationship. So a lot of attention has been given to the importance of trust between an attorney and their client. A defendant who trusts their attorney is considered more likely to share all the relevant information with their attorney, as well as trust their advice. However, under horizontal representation, where a defendant's case is regularly passed between different attorneys, it seems logical to expect that the attorney-client relationship suffers. And so given, with these disadvantages, there appears to be a strong consensus, not just from the ABA, but also scholars and practitioners, that vertical representation is the ideal form of representation, and more public defender offices are transitioning to this model. In terms of the legal position, there's currently no right to continuity of representation at the federal level. So in the case of Greenfield, the Ninth Circuit Court of Appeals did acknowledge that horizontal representation may increase the risk of ineffective representation, but there's no precedent to say that horizontal representation of itself is a form of ineffective representation. However, several state courts have found that a right to continuity of representation exists under the Sixth Amendment. These cases have centered on situations where the judge has removed counsel against the wishes of the defendant, and so they're not directly dealing with the issue of horizontal representation. However, in reaching these decisions, the courts have highlighted the importance of the attorney-client relationship once it's established. And because of the importance of this relationship, they decide that it warranted constitutional protection, even in the context of indigent defense, where defendants obviously aren't given the right of attorney of choice. So while we haven't seen much argument that horizontal representation is better for clients, given the scarce resources available to public defender offices, we believe it's necessary to quantify the negative impacts on defendant outcomes to determine whether the trade-off in using horizontal representation can be justified. So the question that we're looking at is whether increasing continuity of representation improves defendant outcomes. So first, just to give you some background on how we'll answer this question, we're going to be studying a policy change that occurred in the Defender Association of Philadelphia. We believe that Philadelphia is an ideal setting to answer this question, given that the criminal justice challenges it faces are representative of many other major cities in the US. So Philadelphia is one of the largest cities in the US, and in terms of crime, we see high levels of drug offenses and an overrepresentation of minorities amongst criminal defendants. The Defender Association of Philadelphia is the body responsible for the majority of criminal defense in the city state courts. So they represent roughly 70% of all criminal defendants. And while the office is one of the better funded offices in Pennsylvania, the high number of cases that they're responsible for means that attorneys have historically had caseloads above ABA recommendations. So the policy change that we studied occurred in 2015 and was implemented over a period of around 1.5 years. In this time, the Defender Association changed their representation model from being fully horizontal to incorporating a vertical component at the trial stage. In the paper, we refer to this as a partially vertical model. So in our study, we'll be focusing on felony waivers, as they were the cases primarily affected by this change. And this is the term given in Philadelphia to low-level felonies, where the defendant is presumed to waive their right to a jury. Prior to the policy change, the office operated a fully horizontal model for these cases, and so a dedicated attorney handled each of the initial stages of the case. And in addition, the trial attorneys were assigned to specific courtrooms on specific dates. So then an attorney would be assigned to all cases with trials scheduled for their dates. However, if there was a continuance, the trial would just be rescheduled to the next available date, and the case would be transferred to the attorney scheduled for that date, even if that meant that it would be a different attorney. Now, following the policy change, if a trial was rescheduled, it would be set for a date when the attorney initially assigned the trial was scheduled in the courtroom. And the goal here was to have continuity of representation after the pretrial conference until the case was disposed of. However, just to emphasize, the initial stages were still operated horizontally, and thus each defendant, even after the policy change, will still have been represented by multiple members of the office prior to the resolution of their case. I want to start by highlighting some of the reasons why we think this is a good setting to study our question. So the method we use is called difference in difference design. And as the policy rollout was staggered, with courtrooms changing policy on different dates, we'll be comparing outcomes for defendants in courtrooms that changed their policy with those courtrooms that did not yet change. Also, given that court-appointed and privately retained attorneys are never affected by the policy change, it's only affecting the office itself, we'll also be using them as a comparison group. As well as being staggered, the nature of the policy change is such that it's unlikely that defendants were selected into whether or not their cases were affected by the policy change. Courtroom assignment was based primarily on the location of the offense, which determined its geographic zone. And whether or not the trial was after the courtroom changed policy is driven primarily by the date of arrest. It seems unlikely that the policy would have affected either of those. And this will be important for our ability to identify causal impacts. In addition, we received a rich data set from the Philadelphia Defender's Office And so this has enabled us to control for a bunch of the potential confounders. So this includes defendant characteristics such as age, race, and gender. In addition, we control for case characteristics such as the type of charge and its grade, the total number of felony charges in the case. And importantly, we have the identity of the judge. And so this allows us to control for differences in leniency across judges. Finally, we can also control for geographic region of the case and potential time trends. However, while we think this setting has a lot of advantages, we would like to acknowledge the potential weaknesses of our empirical setting. Most importantly, we obviously don't have a transition to a completely vertical representation model. The initial stages of the case continue to proceed in a horizontal manner, so this limits the potential impact of the policy change. However, our view here is, so if we consider the level of continuity of representation in a case as a spectrum, there doesn't seem to be a clear reason to expect a discontinuity with the entire benefit occurring only when we have a fully vertical model. Instead, we'd expect that as we move along the spectrum, we should start to see gradual impacts, and that it is these effects that we're attempting to measure in this study. Another aspect of our study is that while we have great quantitative data on case outcomes, we don't have any qualitative data regarding the experience of either the defendants or the attorneys involved in these cases. These outcomes are still important considerations for criminal justice policy, but given the available data, we unfortunately can't speak to them. Finally, we focus on a small subset of cases, which in Philly are termed felony waivers, as these were the cases that are affected by our policy change. These are less serious felonies where the defendant is presumed to waive their right to a jury. And as we discuss in detail in the paper, this may affect the generalizability of our results, as this is a setting that seems particularly suitable to horizontal representation. So I want to give a brief overview of the data to show how the policy change came into effect. So on this graph, we've got the number of public defender cases per quarter by whether or not they were treated by the policy. So untreated are the cases not affected by the policy change, treated are the ones we consider to have been affected. The x-axis is the date of the first trial in the case, while the y-axis is the number of cases by treatment group. Red are the untreated cases, blue are the treated cases. The gray vertical lines mark the dates when the policy change was implemented for a courtroom. And you can see, so there were 5 different dates when courtrooms changed. And we define a case as being treated if the affected, and by treated we just mean, as I said, affected by the new policy, if the scheduled trial courtroom had switched to vertical representation by the trial date. So you can see as more and more courtrooms switch to the new system, the number of treated cases increases while the number of untreated cases falls. By the end of 2016, almost all public defender cases in our sample were treated. We've got a period of around a year where there's quite a bit of overlap between treated and untreated cases. Now, in terms of our analysis, so to determine the effect of the policy change, as I mentioned, we use a difference in difference regression model. And here I'm showing you a graphical representation of our results for 3 of these outcomes. And those are guilt, incarceration, and probation. All 3 of these outcomes are binary. So the treatment effect, which is on the y-axis, can be considered the change in probability. And the colored circles, circles and triangles, represent the point estimate of the effect. So the whiskers represent the 95% confidence interval, which is the range in which we think the effect is likely to lie. So if we look at guilt, for example, we've got a point estimate of 2.7 percentage points. So cases under the new policy were 2.7 percentage points more likely to end in conviction. However, you can see that our confidence interval includes 0 and even slightly negative effects. And so this impact is not statistically significant. Now, when we look at the rate of incarceration and probation, I show the results in blue for unconditional effects. So this is the effect we just took at a random person from our sample, regardless of whether or not they were actually found guilty. And in pink, I show the results conditional on the individual having actually been convicted. So just picking a person from that group. On average, what's the effect? We can see that for both of these, point estimates are once again positive, but also once again statistically insignificant. And thus we can't conclude that defendants are more likely to be convicted or incarcerated under the this partially vertical system. However, we view these null effects as still being relatively precise. And when you look at the whiskers, you can see that they don't extend very far into the negative range, particularly for the unconditional results. And so our interpretation of this is that we can rule out any large benefits occurring from the increase in continuity under the new policy. Here we've got two more outcomes, incarceration length and probation length. Both of these variables are measured in years, and so the interpretation of the figures are otherwise the same, but the numbers represent the percentage change in years. Here we do have a statistically significant increase when we look at the length of incarceration, both conditional on having received a sentence of imprisonment and unconditionally. However, as shown in the paper, this finding is not robust to alternative specifications, and thus we don't want to place much weight on it. Overall, we think that the policy change did not impact defendant outcomes in our setting. Once again, it's important to acknowledge the limitations of our analysis. So as I said, we're not looking at a switch to a fully vertical representation system. Second, we're focusing on a very specific type of case. These felony waivers are less serious, so the trials are shorter and less complex. And further, the public defenders representing these defendants are much less experienced. So having that idea of multiple defenders reviewing a case might be particularly beneficial here. Also, we're only looking at a subset of relevant outcomes. We're not able to consider things such as the defendant's perception of the legal process, whether justice was served, or an attorney's job satisfaction, which may have impacts on retention for the public defender's office. However, with these caveats in mind, our results suggest that at least in some circumstances, increasing continuity of representation may not actually lead to major benefits, at least in the outcomes we were able to study. That's in settings where its implementation can lead to large increase in costs. It's important for public defender offices to carefully consider whether they really do expect sufficient benefits to justify the costs. Now just quickly over to David for a small pitch.
Hi all. Great presentation, Priyanka, I thought, but I'm biased. This is yes, a short pitch to say first an additional thanks to the Philadelphia Defender Office, who several of whom we spoke to as we're working on this project. And I know that a number of you, some of whom I've met and some of whom I haven't, are also public defenders or involved with different parts of the criminal justice process. And you're here, so you're interested in understanding, learning about it better. That's what we do for a living, and we would love to work with you if there are questions you're interested in trying to answer, and especially if there are data sets that you already have access to with some kind of change, like the kind that we looked at here, or better yet, if there's a possibility of running experiments, and that especially can be possible if there's a consideration of a change that might be underway already, if we can work together and think about ways to potentially implement it or stagger it so we can learn about efficacy of it. So if you're interested in stuff like this, we'd love to talk. Both of our emails are listed there. Also happy to see if you have comments in the chat or live. But thanks, and looking forward to your questions and comments now.
Well, thanks, David, and thanks, Priyanka, also. I will now, as promised, come in and moderate questions. So if anybody does have a question, please do raise your hand. I'm actually going to change my view so that I can perhaps see everybody. But yes, thank you both for thank you both very much for the presentation. I appreciate it very much. One question that I wanted to ask, just to perhaps, so as I hear it, and I think you chose your words quite carefully, Priyanka, no strong evidence of benefits in the way that you interpret your results. Some partial evidence of an increase in incarceration, but you found that not to be very robust. One thing I spotted in the paper was possible evidence that cases were actually resolved faster when they were treated. Was that right? Was that something that you picked up on or thought any further about? I thought that was very interesting in light of the fact that this is clearly an organizational change in scheduling at some level.
Just yeah, having a look back. So there was a small difference in the case duration. So like number of days until resolution. It's not something that we've actually looked into much more. So we did look at kind of some other outcomes such as a number of motions filed, things like that. In terms of the difference in the duration from memory, once we actually include our controls and run this as a regression, I'm pretty sure the change is not actually statistically significant. So I think it might actually just be a bit of noise there.
Thank you very much. I do see we have a question from Laurel Arroyo. And folks, by the way, if you do raise your hand, I'll just ask you to speak or also. Laurel, if you want to expand on this, please do. But she asked, can you explain conditional and unconditional on slides 13 and 14? She was not familiar with the terms.
Okay. Yes. Sorry. So this was kind of me defining these terms. So obviously, so the defendant can only be incarcerated if they're found guilty. So there's kind of two ways we can look at the change in incarceration. So just restrict our sample to people who were actually found guilty and say, given someone was found guilty, what is the change in the probability that they receive a carceral sentence as opposed to something like probation? Or we can, without conditioning on guilt, just look at the entire sample and say, what's the change in probability of incarceration? And that can change through two mechanisms. One, a change in the number of people who are found guilty. So less people were found guilty, that should automatically reduce this unconditional rate of incarceration, while it won't affect the conditional rate of incarceration. Does that answer your question, Laura?
Yeah, thank you.
Thank you very much. I wonder, I mean, I think people in the call must have opinions about this also. And so I just wonder, how do you think we should be thinking about vertical representation as a policy matter? You did talk, Priyanka, a lot about the supposed benefits and also the supposed drawbacks for this approach to doing representation. In light of your analysis, perhaps no strong evidence for those benefits. I wonder if you are looking back at when you first approached the project and what you expected to find, if your thinking on this policy decision has changed in light of your results.
Yeah, so I think my initial assumption was that, yeah, I thought kind of this fully horizontal system didn't really make sense. And I did assume, yeah, as you move to a vertical system, that should be much better for defendants. But kind of the way we're interpreting these results, and I think kind of the message would make is that, yeah, the situation is important to consider. And so if, for example, if you looked at the detail on the Philadelphia process, so the Defenders Association for these less complex felonies uses this fully horizontal method, whereas for very serious cases such as homicides, they use a completely vertical method, is my understanding. So in terms of kind of the benefits you might get from vertical, it might very much depend upon the type of case we're thinking about. And just given, kind of the limited resources of public defender offices, giving the vertical representation does seem to be more costly in terms of resources. There's always going to be a trade-off in terms of implementing it. And so, yeah, we just want to emphasize this idea that given there is this trade-off, it's important to kind of think, is it actually going to lead to large benefits in every case? And we think we're looking at a case where it didn't seem to.
And I'll just add, and I agree with that as well. This is going to sort of double up on what I was saying before. I think like I'd say I was a bit surprised, given that I think sort of the intuition of a lot of public defenders I spoke to was that that vertical is advantageous, and there's this ABA dictate, I don't know, suggestion, whatever, that's the way to go. So so I was surprised. Now again, this is sort of a limited situation, so we definitely don't want to draw like over broad conclusions from it. It's one study, but that's why, again, that's why it's we should do more studies to do it. And I think like that's also one of the fun things about doing the empirical work is you get to test your intuition. And I think when neither of us are professional public defenders, but we know a lot and we speak to a lot, and people have a lot of intuition, but we can get intuitions about things in whatever area that might end up being wrong, might end up being right, might end up being right, but with caveats, might being wrong with caveats. This is why I love doing empirical and particularly experimental research. So yeah, so again, to me, like this is a great example of why it's good to work with for academics and practitioners to team up, and why it's good to test these things empirically.
Thank you both. I see Molly has her hand raised. Could you unmute and speak, Molly? You in a position to?
Yes, thank you. This is a very interesting paper. I was noticing in the equation that you've developed that you have these indicator variables for like public defenders and private attorneys. And I wondered if you had considered at one point creating multi-level or some other type of regression that accounts for, like more than just this indicator, specific people and things like that.
I was just showing the slides of the regression variables. I haven't actually split out the two terms that you were talking about here, but yeah, so we include controls just for the the type of representation. It would have been ideal if unfortunately, our data doesn't allow us to see the identity of public defenders. So we can see a public defender represented the case, but it's just listed as the defender association. So we can't control for individual level there, which if we could, that would be ideal. It would allow us to control for differences in ability across attorneys, things like that. We could do it at just for the privately retained and court-appointed attorneys. We do see their specific identity, but each of them is not handling that many cases. So I don't think that we'd be able to really kind of precisely estimate fixed effect, these indicators there. And that's why we've chosen to just do these kind of broader groups.
Thank you.
Thank you, Molly. We have Marty, our friend from the New York State Defense Association, coming in on the conversation. Also, she writes, as I understand it, there was some improvement overall, just not major in outcome. That seems to indicate it could be a move in the right direction. And if there was vertical all the way through, not just in the end segment as here, it might be much better. You've both spoken to the idea that this intervention was, partial in nature. Do you think that Marty is overconfident, or how would you respond to her idea?
I should actually point out, so the positive numbers here are actually bad things. So, because this is, so for example,
it depends what team you're on. If you think sentences need to be longer, then it's a good outcome.
Well, I would say the Defender Association probably is on the team of not thinking that. So yeah, here, the way you interpret this 2.7 for guilt is 2.7 percentage point increase in the probability of being found guilty under the new policy. So it's actually a small but insignificant effect in the direction that's worse for defendants. So if we kind of was saying, well, that would just be scaled up, we would actually be thinking we're moving more towards more negative impacts. But you could take that interpretation kind of, if you took, say, there are small negatives within our confidence interval, yeah, you could say that that's where the true effect is and we'd scale from there. But given our results, that's kind of the way we would interpret them.
Thank you, Priyanka. My colleague Malia Brink, co-author on the ABA standards themselves. Go ahead.
Well, yes, thank you for that. I want to point out one thing about the new ABA 10 principles, which is that there is actually a minor step away from vertical that's embedded in the representation or in the new principle, which is that there was a recognition that it sometimes conflicts particularly with extremely early representation. And so there's an endnote that actually acknowledges that and says that like duty lawyers and bail units, particularly, and I think this is important, with specialty training may actually be beneficial. And I think that's an important acknowledgement. I will be super candid, right? I no longer work at the ABA, so I can be honest about kind of where I am personally on this as opposed to the ABA standards. And I've always questioned verticality, not because I think it's bad, but because it's not a principle. That's always bugged me. And so I argued that really the principle should be about continuity with the client. And one of the things that I have wondered about, and I'm wondering about this with the context in Philadelphia, and I don't know if you can answer the question, but I've never thought that that has to be an attorney, right? You could have continuity of contact with the client that's done by a navigator or a paralegal, and use specialty attorneys or some form of verticality as long as because really verticality is about continuity of relationship. And so I was wondering if you can tell us anything about the to the extent you think that's the principle that underlies it, that surrounding continuity is relevant to whether or not there'll be any movement in outcome. And so whether there's any context that you can provide about the switch that occurred in Philadelphia in that regard, and whether there are, for example, other aspects of continuity that may be wrapping around this even before the change.
Yeah, on your first point, thanks so much for mentioning kind of that finer detail in terms of the ABA standards. We had actually missed that, and we'll definitely, kind of amend the draft to kind of incorporate that acknowledgement on exactly what the ABA standard is. In terms of, what you're saying about it being not necessarily continuity in terms of representation by the attorney, but having kind of a relationship that's continuous, so they have kind of a specific point of contact, or so someone that they feel like is looking after and kind of watching their case so things don't fall through. It makes sense kind of thinking of that as maybe what the underlying principle should be in our setting. So I'm not aware of them having a setup like that where they had kind of a non-attorney who's assigned to the cases. So I don't want to, my assumption is just because it wasn't mentioned that it probably isn't there, but I can't say anything for sure, but we can definitely ask people from the office just to clarify that point. Thanks.
I just want to credit you, like these are the new 10 principles, so I don't know at what point you were looking at them, like they were, relatively new at this still. So I don't think that's a hard miss on your part. But I think it's important if we continue to study verticality, and I say this to all the other kind of researchers out there, that context is important. And I think if anything, the principle is sort of just misnamed in that regard.
Malia, I think echo thanks for the additional information about the footnote in the principle, and we did look at those. We just clearly didn't look carefully enough. So we will amend things. But I love that you brought up this point about sort of, another way to put this might be continuity of care, right? That's what they call it in medicine, where there's the same kinds of questions, right? Do you pass off patients across doctors, or at the risk of losing information, losing sort of the confidence of the patient in the doctor, or do you keep doctors up for 24 hours straight and you have continuity of care, but they might be half asleep? And it's very analogous to me with this setting, because same thing. Do you pass off clients, and in so doing, sort of potentially lose confidence, potentially lose information, but also maybe you get an attorney who can handle it a little bit better, maybe less sleep deprived, less whatever. So and to me, it's not obvious in either context. I actually, way back in grad school, looked at that medical context a little bit. And there's a lot written there, much more written there than there is in the legal context. So yeah, so I'm generally interested in these kinds of questions. I think your point is a great one. And to me, like, that's where I hope this, you know, if it spurs anything, I think spurring sort of more, you know, subtle questions like that. We're just trying to take like a stab at like some empirical evidence in this one setting, but I hope we can get more, and I hope, you know, we can sort of then, you know, as evidence aggregates, then we can move on to say, okay, well, are there things that are beneficial, and if so, you know, what and what context? But like we're a ways away from that in the empirical realm, at least.
That makes wonderful sense. And somebody Marty put a note in that I think goes, David, directly to that, which is if you look at when medicine does it, it often relates to specialty and expertise needed. And I do think that's an important caveat and thing to think about in vertical.
Thanks, guys. I want to move on to Adeola Ogunkayede's question, which you also put in the chat. I also want to urge everybody, if you've got questions, put them in the chat. You can also continue to raise your hand and I'll invite you to speak. But Adeola writes, how granular are your results? For instance, can you parse for guilty of what, for example? And I don't know if this is possible under Pennsylvania law, if people are convicted of lesser offences than the top charge, or if probation was a more common sentence, if convicted on the top charge, as opposed to incarceration, more common when the conviction was on a lesser charge. So a few diving into the nuances there of your outcome indicators. Any comment on those, Priyanka or David?
Yeah, so we do see our data is at the charge level, so we can see the individual charges and the outcome for that charge. I'm just trying to think. So the one thing we can't see, I believe, is when it's a. Okay, actually, let me just make sure I'm saying this right. So yeah, for example, like the analysis you're suggesting, I do think we would be able to do it. So this isn't something we've currently done, but if we don't have kind of something specifically stated as top charge, but if we found, say, the most serious felony of the ones that they're charged with, we could try to do something like comparing outcomes, yeah, when that's the one that they are found guilty for, or cases where they're found for less severe charges. One thing we have tried to do to kind of get at a similar point, though, is, let me share my screen again, is look at like the closest analysis we've done here is these kind of some secondary outcomes. I actually should have shown this one. Andy asked me about duration, but here we've got one where we term charge downgrade. Here, what we're actually able to see is just that there was a change to the charge. We can't determine whether it was a increase or a decrease in the charge, but our understanding from speaking to people is that in general, these changes are downgrades, or that it's actually just a correction made. But we assume that those sorts of corrections shouldn't be affected by the policy change. And that's why we are kind of considering this impact on charge downgrades. Here we once again do have statistically. Actually, I think this one, once we account for the multiple hypothesis testing, is just statistically insignificant, but it's moving towards actually a decrease in the number of charge downgrades based on our interpretation.
Thank you. Just for my own clarity, as I understand it, you're saying that your data are organized at the charge level. So did I get that right? That Adeola asked about the idea of beating the top charge, but that would require consolidating if a person was charged with multiple things at one time, and that's not how your data are organized. Is that right?
So as in the raw data is we see each individual charge they've got and an outcome for each charge. For our analysis, we consolidate it to the defendant level. So like in that consolidation, we don't really kind of we don't separate out which charge they end up being found guilty for. We're just saying were they found guilty of one of their charges. But we would have the ability to kind of break down which of those charges guilt was the one that they were found guilty for. But maybe sorry, I'm just checking who was it. I'm trying to find who asked this question. Adiola. Yeah, maybe Adiola clarify kind of, is there something specific she's thinking about here? Because at least from our perspective, our thought was like the defendant is probably less concerned about which charge they're found guilty for as opposed to kind of just the overall outcomes of sentence length and whether or not they do have any incarceration. And that's why kind of that was what we focused on. And to the extent that kind of they're downgrading charges, what they care is if that then leads to a lower sentence.
Yeah, thanks. I think both can be true, right? That in the main, one might be most concerned about not being found guilty of anything, and not being incarcerated, period. And right, I think most advocates are trying to work towards that. And then you come up against other realities, injustices, inequities, and right, those change what one's analysis might be of like what is a good outcome. And so, where you might see someone convicted of a lesser offense, and serving a short, relatively short sentence of a few days or time served, right? Since time served is often counted as an incarceratory sentence, right? Like you might get someone who's like, okay, well, I was convicted of not the most serious charge. That helps me for various purposes in my life moving forward. Right? When I think of, non-US citizens, when I think of people who are employed in certain professions or pursuing certain types of employment, licensure, et cetera, the difference in the charge might mean the difference in what one might still have available to them throughout the rest of their life, right? Trying to access, different services and benefits and et cetera. So, right, like that nuance is interesting to me because that's often, a space that people are in the, vast reality of, differences in resources between the state and defense and et cetera. Right. A lot of these trade-offs are often how things, turn for real. And so, just wondering if any of that analysis was done. Right. So I go back to my original statement, which is I think both can be true, that you want not to be found guilty and you don't want to have be incarcerated. But the reality is most people are found guilty in our criminal legal system in the country. And so like, what is the space in which, right, like that guilty pronouncement, right, like might have some nuance to it and some, a lesser impact for someone moving forward from that guilty verdict or guilty, conviction.
Okay, yeah, that thanks for the clarification. That makes sense. Just given this one, so I guess, yeah, as I'd say, probably the closest thing we have to what you're saying is this kind of finding on charge downgrade, but just in terms of how we defined our initial results. So guilt here specifically, have to double check, but I'm pretty sure we defined guilt as whether they were found guilty of a felony. So if they were kind of only found guilty of a misdemeanor, which is where I believe a lot of that distinction happens in terms of your later outcomes, that would be kind of considered not guilty. And then in terms of incarceration, if they were given time served, I believe we're not including that as incarceration. So if they're kind of released just with time served.
Thanks, folks. We're 11 minutes out from the end here, and we do have now lots in the chat. So I want to invite people to unmute in the order that they wrote their messages, and then you can speak your own question. So, Lacey Coppage, can I invite you to ask your question, please?
Sure. Can you hear me?
Mm-hmm.
So I just wanted to better understand when in the felony case the vertical representation was imposed, I guess, because it sounded like you said it was basically imposed once you're at pretrial. So you have your attorney assigned at pretrial. If the trial date gets moved, that attorney is staying on the case. But I mean, so many things have happened in that time. You've probably had a bail review, you've probably had an arraignment, you've had additional bail reviews, you've had motion hearings. Um, I don't know, whatever happens in Pennsylvania. And I just wonder if having the vertical representation imposed earlier is where you're really going to see these significant positive impacts. I mean, having the same attorney at your bail hearing and later having them at your pretrial conference and later having them at your trial is I mean, just from what I know, usually makes a really big difference in a lot of the things that you're saying you can't study, like how the defendant feels, et cetera, et cetera. But I would imagine it would have impacts on the outcome as far as dismissal rates and sentencing to probation instead of incarceration. So I guess yeah, I don't think my question is clear, but did you talk to attorneys too about like in the office about like what their experience was before and after and kind of if they can explain some of these findings that you found and like what would have uh if the verticality needs to be imposed earlier to actually have a positive effect.
Yeah, so we definitely can see the point. So here, yeah, the change is relatively late. So like you're saying, several stages have already happened. The defendant has definitely had representation by multiple individuals before the trial stage, which is the one that is affected. But yeah, kind of my answer to it is, I guess, what I tried to raise in the talk, this idea that, yeah, so we don't have kind of a perfect shift all the way to a fully vertical model. But, and yes, and some of the benefits for that reason probably can't accrue at all. But given kind of a theoretical discussion of the benefits of vertical representation, we would still expect that even this sort of change just at the trial stage should give the opportunity for some of these benefits to start accruing. But we haven't been able to kind of detect anything. However, yeah, that said, we would be, as David flagged, like, keen to do further research kind of on this or other issues in public defense. So if anyone's thinking of switching from horizontals to vertical or did that switch and has good data that'd be willing to share, like we would love to do this study in a setting where there was a complete shift. And we are open to the idea that could definitely change the results in that when we do have kind of a full shift.
Thank you, Lacey. I want to hand it over to Laurel. Laurel, you have a question about impact on attorneys.
Yeah, I guess I really like the fact that you just did this study, and I like the fact that you did it in such a big place, because the big jurisdictions, I think, are the ones that probably benefit the most from horizontal in terms of efficiency. But I wonder, I do wonder if it would make sense to really think about this in terms of a retention issue, because some places when they switch to vertical, it really messes up the dynamic of the office. And so, but the challenge will be whether you have a leader who's into it and then the union that's not, or something like that. But finding a place where everybody's willing to give the data up on the switch and how does it affect attorney retention and health, and because the stress is different when you're going to one courtroom versus 8 courtrooms when you have to run around, and whether or not you can actually try cases because you're you're so busy kind of juggling, so it doesn't really fit in your schedule. So I think those are kind of another thread to explore, which you probably were already thinking about, but just wanted to throw that out there. It's not really a question, more of a comment.
Thanks for the comment. And yeah, it's definitely something that we've thought about, kind of just the impact on attorneys. To be honest, I was actually thinking of it from the other direction, that you might have kind of more satisfaction if you've been able to like build more of a relationship with the defendant, kind of you really owned that case and you kind of maybe that in that way own the successes a bit more. So I was thinking vertical would, from that perspective, probably lead to better retention. It sounds like you're kind of focused a lot more on just could actually make the job a lot more stressful because of some of those inefficiencies we mentioned, where you're running around, things like that. And if definitely if someone's willing to kind of share that sort of data with us in one of these settings, we'd be very keen to look into that. And because I like, given the costs associated with hiring and training people, we could imagine this would actually be quite a significant consideration in choosing this policy.
Yeah, and I'll say that just sort of we very much thought about this, and sort of we would just need data on attorney turnover, attorney comings and goings, and we'd be able to add that analysis.
Thank you. So we're inside the last 5 minutes. David, in case folks missed it, has shared emails in the chat. So if you want to reach out to David and Priyanka later, you can do so there. We've got a few questions that I'm afraid we're not going to be able to get to, but we do have time for one more. And Camilla Hsu, you are actually the next one in line. So do you want to take it away, Camilla, if you're still there?
Yes, I will. I think it could be informative to sort of like frame the extent of the limitation, extent of the partiality in maybe in terms of sort of how long as a percentage of the overall case the cases were handled horizontally versus vertically, and also to give a little bit more description to what can occur under Pennsylvania criminal procedure during that horizontal phase, because as Adiola was saying, most cases are resolved with pleas. So if we're talking only about an extremely small percentage that sort of think that they're going to trial by a very late stage of the case, could be interesting to know that is what how the data are cabined.
So just to your second point, so I'm just looking at the paper to get the number, because so these are so in general, obviously, kind of the majority of cases are settled by plea generally in the US, but actually in this set of felony waivers, we actually have a much higher rate that are not settled by plea. So in our data set, it was only around just over 50% that had a guilty plea. And that's much lower than I think if you look at just criminal cases overall. So I think it's probably lower than you had been thinking. In terms of how to represent the kind of level of initial horizontal, that's a good suggestion. I do worry though that might actually be a little bit misleading, in that if you just looked at the length of the case in days, the trial stage, I'm pretty sure, is actually a huge chunk of it, just because those initial stages have kind of relatively short periods of delay that are allowed in between them, whereas the trial stage could drag on for a while just because you've got continuances, and then this trial ends up getting scheduled much later. And that doesn't necessarily reflect that there's kind of much more work there than is happening, say, in the first 24 hours, which is when you have to have the first hearing.
Yeah, that's a good point. I wonder if there's other ways to express it, like number of appearances in court or something like that.
Yeah. I mean, maybe that would be that's a good suggestion. And definitely something we could do. I'll have a think about that, but thank you.
Well, thank you so much again, Dr. Goonetilleke and Dr. Abrams. It has been an absolute thrill to have this kind of early look at this critical work that you're doing. We're so pleased, even if and very hopeful that maybe one thing that comes out of today is you do get even more data to look at this even more deeply. Thank you also to everybody in the audience who took time out of your day to come and engage. And I'm so sorry that the questions that are coming in the chat, we're not going to get to all of them. But as Blaine indicated, the recording will be up on YouTube just as soon as we can get it there. And we can all stay in touch that way. In the meantime, thank you so much again, and we'll see you all back here next time.